what is your position, or what are your positions, excuse me, on the motion to retain?
Your Honor, I think that the department's requesting a motion to retain based off of extraordinary circumstances. And while my client isn't opposed to the case being retained, I think it would help for us to have either an FGC or a mediation prior to agreeing to the motion to retain so that we can figure out exactly what the department wants. I haven't conferred with the department with regard to the motion to retain, and my client's in full compliance with her service plan. So I'm leery about just agreeing to it without steps to transition the kids back home, considering the level of compliance of the parents. And I know that there's no evidence of that in front of you right now, aside from court reports and such, but that's my position. I would like to confer with them prior to having my client agree to anything.
All right, Mr. Weatherby. Did we lose Mr. Weatherby? No, he's there. Mr. Weatherby, if you could. There you are.
Here I am. I'm sorry, I didn't realize I had to log back in when I came out of the group breakout. We're not opposed to extending the thing. My client's doing a little bit of catch up because he was incarcerated for a while, so that's all right. But don't really have any objection to knowing what the department's wanting to do. If we could set up a meeting or a mediation or something. I haven't heard much from the department. So,
well, and I think Ms. Surratt being here is indicative of the fact that we've got some shuffling around with department attorneys, and she was gracious enough to cover today. So would the department, from where you stand right now, Ms. Surratt, would the department be opposed to a reset in order to meet and see if some of these details could be ironed out?
No, we would not be opposed. I think that we thought there was going to be some kind of mediation as to how we might proceed in this case. And I guess that did not happen, or some kind of meeting. The mom did just start her unsupervised visits this month, which is why we're wanting to continue. But we do want to work up to her having placement and doing overnights. So we don't have a problem having a meeting about that.
Okay. Ms. Sims?
I don't have a problem with the reset, Your Honor.
Casa?
We were under the impression there was already an agreement, but we have no problem with a reset and mediation.
Okay. Ms. Greenlee has given me June 27th at 9:30. Then what I would like to do is, I feel like, and I'm proud of you both, Ms. Sampson and Mr. Menchaca, for the progress that you're making. It seems as if things are, for the most part, amicable at this point. Do you think an FGC would be effective enough, or do you think that you need court order mediation?
I think an FGC would work, Judge. I think that the issue is just that not having enough information over what the department is wanting to do moving forward. I just saw the motion filed and we didn't really discuss anything around it. So I think that's what the issue is with both parents. We just need more information.
Anybody have a different perspective, or does everybody agree with Mr. Colsta?
I'd agree with that. I think we can work it out in that format.
I agree as well, Your Honor.
Okay, well then, not having heard any objection, the court will grant the party's request to have a family group conference prior to our next setting. Our next setting will be the trial setting. So court's resetting the trial to June 27th, 2024 at 9:30. June 27th, 2024 at 9:30. And we'll obviously abate the motion to retain to that date as well. And Mr. Menchaca and Ms. Sampson, this is your notice that we're going to come back for trial June 27th, 2024. And you need to make sure you stay in touch with your attorneys so you can get the dates and times of that meeting. And you need to show up to that meeting ready to work and figure out how we're going to move forward with this potential transition plan, okay?
Yes, sir.
Yes, sir.
Ms. Nix, placement's good. Nothing to worry about there?
No, Your Honor, the placement is very good, and no, there's nothing to worry about. And
No
the
other
parents-
orders needed today?
No, and the parents are doing exceptionally well.
Good. Well, we are proud of both of them. All right, well then, I'll see you all back June 27th, 2024 at 9:30 after your FGC. Thank you for your time and your service. If nothing further, District Court of Gillespie County, Texas. The court is broadcasting outside of Gillespie County via YouTube and Zoom. Are there any objections?
No, Your Honor.
All right, then with that, Ms. Surratt, would you please begin the announcements?
Michelle Surratt, attorney for the department, present, ready to proceed.
Shelley Nix, belong permanency specialist.
Ashley Crouch, belong permanency supervisor.
Irene Acosta, attorney for the respondent mother, Brianna Sampson. Ms. Sampson, can you unmute and announce, please?
Brianna Sansom.
Kendra Sims, attorney ad litem for the children.
Mr. Menchaca, can you announce for me, please?
Here,
I need you to state your name for the record, please, sir.
Eddie Menchaca.
Thank you. Anybody else that needs to announce?
Brenda Ebersfeld, Hill Country Casa, attorney ad litem for the guardian ad litem for the children. Excuse me.
I'm present. Sorry about the coat and tie there in the car because I got a hearing in Kerrville in a little bit.
Okay. All right. We are taking a record. If you just do me a favor and just state your name as well, please.
Oh, Charles Weatherby, attorney for the father of the oldest child.
All right. Thank you. And Mr. Menchaca, I'll need you to keep your video on for me, please. Okay. We're here today for a final trial. There's a motion for extension on file. Ms. Surratt, how does the department wish to proceed today?
Your Honor, we would like to re-urge our motion to retain that was filed back in May 17th. There was, I think at the last hearing, there just needed to be a meeting for the parties to know how this was moving forward as far as family reunification. There was an FGC on June 18th where everybody was able to come together and outline how this would work as far as unsupervised visits for Mr. Menchaca, and mom was going to be able to start, Miss Sansom, to be able to start going in overnight with the placement and do some overnight visits to move towards that reunification, hopefully in July.
Okay. And were the parties able to come up with those agreements and structure that plan?
I believe so.
Okay. Is there any other response to the department's request to extend the case? Any objections?
No objection, Your Honor.
No objection, Your Honor. I believe that there's a good plan in place for both of the parents to be reunited with the children, with the child.
Okay. Ms. Sims?
I'm in agreement, Your Honor.
Casa?
We are in agreement.
Okay. Then I think it would be appropriate for the record, Ms. Surratt, if we could put a little evidence on as to extraordinary circumstances and best interests. I have it down as a 263-401B. Is that correct?
Yes.
Okay. If you want to put a little evidence on with Ms. Nix, I'll give everybody else the opportunity to cross if they want.
Certainly. I'll call Shelley Nix.
All right. She's been sworn. You may proceed.
And Atticus will be 2 next month. And Sandra just turned 1.
Yes, she did. She just had her
Okay.
first birthday.
Where are they currently placed?
They are living with their great grandmother in Kerrville.
And are they doing well in that placement?
They're doing very well.
Up to date on all their medical, dental appointments?
Yes, they are.
And the parents, let's talk about the mom, Miss Sansom. How is she doing on her family plan of service?
She's doing very well. I would categorize her as in full compliance with her family plan of service. She has completed parenting. She completed a psychological. She is engaged in counseling, and that is ongoing, individual. For drug treatment, one of the reasons for our exigent circumstances is since from September to February, she was in a drug facility treatment program and not available to participate in any other services, but she finished that. She came out, moved back to Kerrville. She's on probation, so she was required to do an outpatient program through them. That was completed as well. She's in compliance with her probation requirements. The only outstanding thing for her to do right now is to continue to be a parent to her children as fully as possible. For her, Mr. Menchaca, to engage in family counseling, and for her to continue her own individual counseling as well as ongoing drug testing. For the court's record and the parties, her last drug test was a hair and a UA on June the 19th, and both were negative. She is soon to be approaching 1 year of sobriety, and I'm very proud of her, but that was primarily in a facility. And so she's been out for 4 months, but we want her to be able to continue to demonstrate sobriety outside of treatment.
And after the FGC and the meeting going forward, towards reunification, she's been allowed to stay overnight in the home of the great grandmother.
Yes, I checked with her about that. She hasn't yet spent the night. She said there's an air conditioning issue in the guest room where she would be staying. But she has jumped in wholeheartedly with the unsupervised part of it, taking the children to daycare, picking them up. She said she was there last night until after 8, got them bathed, put them to bed. So although she has not had the chance to spend the night, she said as soon as the AC issue is resolved, she'll do that.
And how about, well, let me back up a minute. So really the reason that we're asking for this extension is because most of this case so far, she's been in some kind of facility for rehab. Is that right?
Yes, that's correct.
Okay. And so while she's working her services, she needs to complete those and continue to show sobriety outside of a facility.
Yes.
Okay. And the father, Mr. Menchaca, how's he doing on his family plan of service?
He's doing very well. Also, he too was incarcerated for most of the case beginning last August until mid-April. So he's only been out for 2 months, but he too is almost approaching a year of sobriety. His last drug test on the 19th AUA was negative. All of his drug tests since his release have been negative. He has engaged in counseling. He has engaged in parenting and is about to complete that. His psychological is pending. The paperwork is in. I think the appointment still needs to be set up. He is participating in an intensive drug treatment program outpatient through his probation, and that's 4 times a week. That is very intense. And in compliance with that, they're both, I forgot to mention, they're both in AA together. And he is going to be participating in family counseling with Ms. Sampson. And to give them full due credit, they're both holding down full-time jobs while doing all of that.
And where are they currently living?
They're living in Kerrville, not really far from where the children are. They're living with Miss Sampson's father. And although you talked about reunification and the overnight visits, right now the plan is for Mr. Menchaca and Miss Sampson to move into Miss Harris's house, kind of a backwards family reunification. We're going to put the parents where the children are.
Okay. And has there been a plan established regarding Mr. Menchaca starting some unsupervised visits?
Immediately following our FGC on the 18th, we gave him free rein. He's working a lot of hours, and as you heard through my testimony, juggling a lot of services, but he's spending as much time with the children as he can. They had a special little outing with the kids for Sandra's birthday on Sunday.
And so if everything is going well in July, it will be staffed for the parents to move into the home where the children are.
Yes, I'm already scheduled to staff internally with our Belong Permanency Director. And following that, I will confer with CASA and with Ms. Sims. And if we're all in agreement, and check in with Ms. Harris to see if she's still on board with everything. And yes, the plan would be for them to be able to move in July.
Okay.
And begin.
Okay, thank you. So basically, we're just needing this extension because of the parents just needing to complete their services for them being either incarcerated or in a facility through the majority of this case.
Yes.
But they have been actively working these services since being released.
I find their participation commendable, and I just want to give them a lot of credit. I think they both demonstrated exactly the way parents should handle a CPS case, how to do it and how not to do it. And I think they've been exemplary.
So you're asking the court at this time to grant the department's motion to retain, but maintain the department as temporary managing conservator and maintain the placement?
Yes.
Do you believe this to be in the best interest of these children?
Yes, it is very much in their best interest.
And they're doing well with the increased visitation and unsupervised visitations?
Yes.
I'll pass the witness.
Ms. Acosta?
Thank you. After the parents move in with placement in July, how long do you anticipate this case remaining open?
Well, I am aware we don't have to do the whole 6 months, although we've asked for it. I'll be monitoring very frequently, and I would hope after 3 months, but I wouldn't want to commit myself to that.
All right. And is there anything else that Ms. Sampson needs to be doing right now to remain in compliance?
No. Other than starting the family counseling is the main thing that has not been done yet, but she's scheduled to start that in July. So, and continue to take drug tests and continue her counseling with Ms. Chavez.
All right, thank you. I'll pass the witness, Judge.
Mr. Weatherby? I couldn't hear you if you answered.
No questions, Your Honor.
Okay, I wasn't sure. Ms. Sims?
No questions, Your Honor.
Okay. Does anybody have any other witnesses or testimony they want to put on?
No,
No,
Your
Your Honor.
No, Your Honor.
Ms. Sims, what are your thoughts?
Your Honor, the children are doing very well. And as Ms. Nick said, so are the parents. I was able to visit when the mom was having one of her unsupervised visits. And I mean, it was great. The kids seemed to be bonded to her. I'm glad we're moving in the direction we are because you can tell the kids love them. They want to be around the parents, and the parents have done what we've asked them to do. The kids are in daycare. That's kind of a new thing, which is great. It gives the great grandmother a little bit of a break. I would ask that the court order that belong pay for Sandra's daycare just to give the grandmother a little financial help. But other than that, I think everything's going very well.
All right. Casa?
Well, so far, things seem to be going very well. I would want to remind the parents it would be great if they could, when they are having their visits, that they take full responsibility for the children with the feeding and the diapers and all that, so that they know what it's like to take care of two babies by themselves. But otherwise, things so far are going well.
All right, thank you. Okay, then for the purposes of the final trial, the court will find that pursuant to Chapter 263, 401B, that extraordinary circumstances necessitate the child remaining in the temporary managing conservatorship of the department and continuing the appointment of the department as temporary managing conservators in the best interest of the children. Court will retain the suit and schedule a new dismissal date. That date is going to be January 18th, 2025. Our next permanency hearing will be September 26, 2024 at 11:30. September 26, 2024 at 11:30. And our final trial is going to be reset to November 21st, 2024 at 11 a.m. November 21st, 2024 at 11 a.m. And again, that dismissal date is January 18th, 2025. Furthermore, the court will specifically find that extraordinary circumstances exist as the parents have made a good faith effort to successfully complete their service plans but need additional time. And on completion of the service plan, the court intends to order the children to the parent. The court will also make a finding that the parties have met and developed a plan to start transitioning the children. Court finds that to be in their best interest. As far as the permanency hearing for today, court finds that the permanency goal at this time is family reunification, and that permanency goal is in the best interest of the children. There's no Indian child heritage in this suit. The placement of the children is safe, appropriate, meeting their needs and in their best interest to continue at this time. Court finds that they're up to date on their checkups and all their needs are being met. Court finds that both parents are in compliance. And although we're on the right track, Obviously, we're not returning the children yet, so the court will also make the findings that it's not safe to return the children today to either parent. And as of today, neither parent has fully addressed the concerns. It's best interest of the children to remain in the temporary managing conservatorship of the department. We'll order belong to pay for Sandra's daycare to help grandma out a little bit. Hopefully it won't be for too long. Again, that next permanency hearing is going to be September 26, 2024, 11:30. I want to commend both of you parents, Mr. Menchaca, Ms. Sampson. Things are going really great right now. I'm very proud of both of you and the progress that you've made. And you're in the thick of it right now, and you continue to move forward. So just keep doing what you're doing. Remember, you've got some more time. We're on the right track. Everything looks pretty good so far, but we're still in the CPS case. And I have to admonish you that, you're originally given a year. You have to prove that you can provide a safe, stable, violence, and drug-free home within that year. And if you can't, then your rights are subject to further restrictions or termination. We just extended that year to give you some more time to finish these things up. So take advantage of that time because it will come to an end. And hopefully, as Ms. Nix testified, we can be done with this long before that 6 months is over. So good job to both of you. I'm very proud of you both. You're doing the right thing.
Thank you.
You're welcome. Ms. Surratt, is there anything I failed to address?
No, Your Honor.
Okay. Well, thank you all for your time and your service. And if there's nothing further, all parties are excused.
Thank you.
Thank you,
Thank
Judge.
Ms. Jackson?
No objections, Your Honor.
That's
No
our only
objection.
trial today. All right. With that, Ms. Surratt, would you please begin the announcements?
Your Honor, Michelle Surratt, attorney for the department, along with Alejandra Zertucci, I hope I pronounced that correctly, who's the permanency specialist, and her supervisor, Ashley Crouch.
Alejandra Certuche, permanency specialist with Belong.
Kathleen Savage, attorney for the respondent mother, Blanca Ledesma. We're ready, Your Honor. And Blanca, if you can unmute and announce your name for the record.
I don't know if there's anybody there to assist with the equipment. So we'll keep taking announcements as we wait for her.
Irene Acosta for the respondent father. He is not present. I'm ready for the purposes of this hearing, Judge.
Kendra Sims, attorney ad litem for the child.
Marcus McLemore, Low Country Casa supervisor.
I still don't have your client, Miss Savage, but let me ask you this question. If for some reason they don't get the audio and the video hooked up, are you ready to proceed without her?
Your Honor, yes, I think we can get the testimony we need through the caseworker and Miss Laura Ledesma. I was just informed that we might not even need the hearing. That's why I wanted to touch base with her, but I don't know if she can hit *6. I think she's just calling in, so it's just audio.
Yeah, it might just be audio. Whoever's on there with Miss Ledesma or Miss Ledesma, if it's just yourself, if you can hit *6, it should unmute you.
Hello, this is
All right.
Ledesma.
Okay, Miss Savage, you need a breakout room?
Yes, Your Honor, very briefly.
All right. Okay, Miss Surratt, if you want to, I guess Miss Certuche is the person that you want to hear from, Miss Savage?
Yes, Your Honor.
Is that who you were going to call, Miss Surratt?
Yes, Your Honor.
Okay, you may proceed.
How old is Sebastian?
Sorry, I wasn't expecting that question. He's just shy of a year, I believe.
And he was he was removed since the last hearing to a different placement, is that correct?
Actually, prior to the last hearing, he was removed.
Okay, and why was that?
There was some allegations concerning the husband of the aunt from the home he was living in. They were concerning allegations, so it was in his best interest to be moved to a foster home.
And what happened with those allegations?
So the ones on the other children in the home were closed on a disposition of ruled out. However, the one on the daughter who initially made the outcry was closed with a disposition of unable to determine, as she recanted her story.
Are there still criminal investigation going on regarding other possible victims?
Yes, ma'am.
And is that the concern of the department in not returning Sebastian to the maternal aunt's home?
Yes, ma'am.
And how's he doing in the current foster home?
He's doing really well. He has adjusted very quickly to the foster parents, and he attends daycare daily, which has also been really good for him as he's improving a lot more. He's learning shapes, he's recognizing colors, he's eating really good. His little teeth are starting to come out. So I would say he's thriving.
And he's up to date on all his medical, dental appointments.
Yes.
And the department is wanting to extend this case at this time due to the mom being released next month from SafeP. Is that right?
Yes. Yes, ma'am.
How has she been doing in SafeP?
She's been doing really well. She's been compliant towards her service plan. She has maintained like a higher level at her unit where she oversees other inmates. She graduated from her parenting classes at her facility. So I would say she is doing pretty well where she is.
And the department would like to work with her when she gets released next month for her on her other services.
Yes, absolutely.
And Mr. McNamee, he's still incarcerated?
Yes.
And he will probably not get out within the next 6 months, maybe?
Oh, no, definitely not. He won't be out for quite a while.
Has he been doing anything while he's been incarcerated?
He was participating in courses called Quest for Manhood, I believe was the name, as well as AA. And I believe he had like about 7 more weeks for that program to end.
Does he have contact with you?
We have contact through a courtesy worker that goes out to see him monthly.
Does he send anything for Sebastian?
Not to my knowledge.
Okay. No notes or anything like that?
No.
And going back to Miss Ledesma, she had been able to see Sebastian back in January and February. Is that right?
Yes, the aunt was able to take Sebastian to the facility to visit with her.
But she hasn't had any visits since February?
No.
But you maintain contact with her?
Yes. I try to as best as I can. It gets difficult to get a hold of her with the jail. They're not very responsive, but I communicate often with the courtesy worker every time she goes to see her.
So at this time, you're asking that Sebastian maintain the placement in the foster home where he is doing well?
Yes, ma'am.
And the boyfriend still remains in the home of the maternal aunt?
Yes, that's correct from what she told me last.
And you're also asking that the court grant our motion to retain to give Ms. Ledesma time to continue working her services when she's released from SafeP?
Yes.
And that the department maintain temporary managing conservator?
Yes.
Do you believe this to be in the best interest of Sebastian at this time?
I do.
I'll pass the witness.
Ms. Savage?
So there were 3 allegations, 2 have been ruled out and 1 was unable to determine?
No. So for all the children in the home, the other children were ruled out. However, the oldest daughter, hers was unable to determine. And then there are 2 like outside allegations that are being investigated by Fredericksburg Police Department.
So the oldest daughter in the home and then 2 children outside of the home have made allegations.
Yes.
Okay, but those are all against the live-in boyfriend, not any against Miss Laura Ledesma, is that correct?
Correct.
And the department does not have any concerns for Laura Ledesma. It's the boyfriend that is the concern for Belong, correct?
Yes. Yes, ma'am.
If he were to not be in the home, would Belong at that point be able to reconsider placing Sebastian back in that home?
Yes, if he were not in the home, it could be reconsidered.
Okay, because up until that point, Sebastian had been in that home for the duration of the case and had been doing very well there, correct?
Yes.
Okay. Upon Miss Blanca Ledesma being released, would there be any objection to Laura Ledesma being a support for Blanca, not around the live-in boyfriend?
Oh, no, absolutely not. We would absolutely encourage her to be around as a support.
Okay. And are there any services that Miss Ledesma will need to engage in once she's released from safety?
So she will be doing like random drug testing already. So we'll just need to have her release of information that we were able to obtain those results from her. And I would like to get her scheduled for a psychological and a psychosocial, and for her to follow any recommendations that might include individual counseling. But she has completed the portion for substance abuse while she's been in SafeP, and her parenting as well.
Okay. And will you also look for virtual providers to just help with any transportation issues upon Miss Ledesma's release from SafeP?
Yes.
All right. I'll pass the witness, Your Honor.
Ms. Acosta.
Thank you. Do you know how often the courtesy worker has contact with Mr. McNamee?
She goes monthly.
And the courses that he was taking, do those fulfill any requirement of his service plan?
They do, the AA, but I don't think there was enough mental health at his facility. And I would need to dig into the Quest for Manhood classes because I'm not sure. It doesn't specify what those are.
Okay. And if for some reason he becomes eligible for parole and is released while this case is ongoing, will Belong continue to provide him with services?
Yes, we'll make referrals as needed if and when he is released, whether it's on parole.
I'll pass the witness, Your Honor.
Ms. Sims.
Yes. Ms. Sertucci, Miss Ledesma is going to be released, you said in June, correct?
June 26th.
June 26th. Do you have a plan for visitation with her yet?
We talked about it briefly yesterday, so it would just require some transportation assistance to get either Sebastian to Fredericksburg where she is, or we can meet somewhere in the middle, like in Bernie. But she was okay with either one.
Do you have, or does Belong have a problem with Miss Laura Ledesma supervising these visitations?
No.
No further questions, Your Honor.
Any redirect?
No, Your Honor.
Any other cross? Any other witnesses from the department, Mr. Rott?
No, Your Honor.
Do any of the other attorneys have any witnesses to call?
No, Your Honor.
No, Your Honor.
All right. Ms. Sims, what are your thoughts on everything?
Your Honor, Sebastian is doing very well at his placement. Like Ms. Sertucci said, he is walking, meeting his milestones. Everything seems to be going very well. He's happy. I do have concerns about, well, let me start. When Sebastian was with the aunt, I did not have any concerns about the aunt's care of him, but I do have concerns about the husband that resides in the home and the allegations that are still being investigated. So at this point, I feel like it's in his best interest to remain in his foster home, especially because he is doing so well there. I don't have any problem with the aunt supervising visits with mom or being support for mom or any of that. I just don't think it's in his best interest to place him there right now.
All right. Casa?
We're in alignment with Kendra. We don't believe that it's a good idea to move him back in with Laura. We're fine with her being a support, and we're also in favor of an extension so the mother can develop a relationship with her child.
Is Miss Ledesma's, is it her husband or her boyfriend? I think I've heard both.
I don't think they're legally married, Your Honor, but they've been in a relationship for like a long period of time.
Okay. All right. Based on the agreement of the parties and the evidence and arguments of counsel today, court finds that the department's motion to retain this case pursuant to Chapter 263 401B is in the best interest of the child, the court will grant the motion. The court will maintain or retain the suit on the court's docket for a period not to exceed 180 days. And the court will reschedule the trial, permanency hearing, and dismissal date. Those new dates are new dismissal date, January 25th, 2025. January 25th, 2025. Our next permanency hearing is going to be August 22nd, 2024 at 11 a.m. August 22nd, 2024 at 11 a.m. And the final trial is reset to November 21st, 2024 at 10:30 a.m. November 21st, 2024 at 10:30 a.m. The court will continue to make temporary orders for the safety and welfare of the child. And as I've already stated, I've reset the trial. As far as the permanency hearing today, and the court does find that extraordinary circumstances necessitate the child remaining in the temporary managing conservatorship of the department and continuing the department as the temporary managing conservator is in the best interest of the child. I think I said that. For the permanency hearing today, court finds that the permanency goal at this time is family reunification. Ms. Sedatucci, I don't know if I heard you say it. There's still no Indian child heritage in this case, correct?
Correct.
Court finds there's no Indian child heritage. Court finds that the foster home placement in Bexar County is safe and appropriate, meeting Sebastian's needs and in his best interest to continue in that placement. Court finds it's the least restrictive placement available at this time. Court finds that Sebastian is up to date on his checkups. Court heard no evidence of any other concerns or any special services at this time. Court finds that it's in the best interest of the child to allow the aunt to Ms. Ledesma to supervise visitation when mom is released from safety and provide support services, but it's not in the best interest of the child to return to placement with her at this time or to have contact with the husband of Ms. Ledesma. Court finds that mom, I'm going to get these names right, Ms. Blanca Ledesma is in compliance with their family plan of service. And I'm really proud of the efforts and the progress that you've made, Ms. Ledesma. It sounds like you're doing really great there in safety and you're on the right track. Court finds that she's aware of her family plan of service, has a copy of it. I don't know that I heard this specifically. If I did and I don't remember, I'm sorry. Would you say that Mr. McNamee is in compliance with the services that are available to him? Or would you say that he's not in compliance with his family plan of service, Ms. Zartuche?
I would say he's in compliance with what's available to him at his facility.
Okay, that is the finding that I want to make then. I'll find that he's in compliance with the services that are available to him at his facility, which would, I think, be minimal compliance with his family plan of service. Court finds that he also has a copy of his family plan of service or is aware of it. As of today, it's not safe to return the child to either parent. Court finds that as of today, neither parent has fully addressed the concerns that brought Sebastian into care. Our next hearing is going to be that August hearing that I just told you about, August 22nd, 2024 at 11 a.m. I had ordered the parties to mediation back before trial. Since we've got an extension on this case, I want to make sure that I'm not missing something here. Do you all think you're going to need the full 6 months, or should I send you back to mediation sometime halfway through?
I don't know this case as well as anybody else, but right now I would think we would need the 6 months just because we have mom is not getting out until June, and then to try to get her engaged into the other services that she's going to need and to do the psychosocial and follow up any recommendations of that psychosocial. I believe it may take us the whole 6 months.
I tend to agree with that. I just didn't know if anybody else had any other thoughts or if there was anything else I wasn't aware of. I'm not hearing anything, so I'm going to hold off on making any mediation orders at this time. We'll take it up in August. Anything besides an admonishment that I have forgotten or failed to address?
No, Your Honor.
Judge, I just wanted to mention briefly that Sebastian did have the other ECI assessment on April 18th that you had ordered with foster parents, and he did not meet the requirements.
All right. Sounds like he's doing really well. Thank you, Mr. Teacher. I appreciate you updating me on that. Okay, then Ms. Ledesma, I just have to make sure you remember, and if we could put it in the order for Mr. McNamee, since he's not here, that the state of Texas initially gives parents 12 months to demonstrate they can provide a safe, stable, violence, and drug-free home for their child. In the event they cannot demonstrate that, their rights to their child are subject to restriction and or termination. We've just extended this case, so you're getting more than 12 months. However, you're still on a timeline. And at the end of this 6 months, if you haven't been able to make that demonstration, then your rights are still subject to restriction and or termination. Okay, thank you all for your time and your service. See you back in August. If there's nothing further, all parties are excused. Westby County, are there any objections?
No, Your Honor.
No, Your Honor.
With that, Ms. Surratt, would you please begin our announcements?
Michelle Surratt, attorney for Belong. I'll let them announce themselves.
Katarina Lewis, Belong Permanency Specialist.
Ashley Crouch, Permanency Supervisor for Belong.
Kathleen Savage, attorney for the respondent mother, Mariah Caldwell. Ms. Caldwell, can you unmute yourself and announce your name for the record?
Oh, yeah.
Mariah Caldwell.
Quincy Brandon.
I'm going to mute you just for a second, Ms. Caldwell. Go ahead, Ms. Brandon.
Thank you, Judge. Quincy Brandon standing in for Richard Saldivar. I believe his client is present, Judge, if his client could announce as well.
Mr. Rodriguez,
Yes, sir.
if you could just state your name for me, please.
Emilio Rodriguez.
Thank you, sir.
Kendra Sims, attorney ad litem for the child.
Marcus McElmore, Hill Country CASA Supervisor. Linda, if you could unmute and announce, please.
Linda Seawald, Hill Country CASA, guardian ad litem for Millie.
All right, we are here for a final trial, and we have a motion to retain 401B motion, and based on what we were here for last time, we reset, pushed trial day back because mom was reunified with Millie, and so we wanted to kind of see how things were going up to this date. My presumption is that things, based on what I just saw, are going well, and you just want more time, but maybe there's something I don't know. So are there any objections to the department's motion to retain?
No, Your Honor.
No, but I would just ask that we don't utilize the full 6 months if we can have a closer trial setting, because Millie has been with Mariah since January.
Okay. Ms. Surratt, I know you're new to this case. Is there anything that you want to add on behalf of the department in support of the motion before we hear testimony?
Your Honor, the reason for the motion is basically her living situation is just to make sure, because the place that she was in, she, I guess, got kicked out of there for what that's worth. And so she is living on the property with the prior placement of Millie. But that's not a long term. And so that's just the department's concern, is to make sure that she has a good living situation. We're very happy with the progress on her service plan. And then also the father is still in his sober living placement and to continue to work services with him. And so that's the need for a little bit more time.
Okay. I'm just looking at my notes here. This is our first extension. So I guess the strategy here is file the 401B, and then if for some reason more time would be needed, then you could look at a transitional later.
Yes, Your Honor.
Okay. All right. I understand. Okay. Then Ms. Surratt, you want to ask Ms. Lewis a few questions about the motion, and then why don't we go ahead and take testimony on the permanency hearing as well, if you would, please.
Yes, sure. And Millie is going to be 2 here in a week?
Yes.
And she appears to be good because we see her on screen, right?
Yeah, she's doing very well.
Where are Millie and Mariah currently residing?
They're currently residing in Harper, Texas, Gillespie County, at Miss Angela Hofford's home. She was the caregiver for Millie prior to reunification with Mariah.
Is this a long-term living situation?
It is not.
So what has Miss Caldwell been doing to try to locate some kind of permanent living situation?
She has talked to me about going back to the Houston area where she has family support over there. And she plans on looking into housing coming up probably in June and getting on the list so that she can have housing where she can have her children with her.
And she has another child, is that right?
Yes, she does.
Okay. And how old is it's a male, right?
Yes.
And how old is he?
He is about 5-6 months.
Is Millie up to date on all her medical dental appointments?
She's up to date on her medical, and we are getting a dental scheduled for this upcoming month. So I will get that scheduled.
Does Millie go to any kind of daycare, or does she just stay at home with Miss Caldwell?
At this time, she's just staying home during the day with Miss Caldwell.
And was she evaluated for any kind of ECI services?
Yes, she was, but she doesn't need any. They did not recommend any. She is on target. She is a very smart little girl.
And it seems like very active.
Yes.
How about Miss Caldwell on her service plan? How's she doing on that?
Yes, Miss Caldwell's completed all of her services. She just continues to drug test for me and has been negative on that this month and prior. And then she also is getting into counseling with Trisha Boone. She had an appointment this week and she's going to just continue to see her since she's virtual, just in case she does move back to Houston.
And so what is the concern of the department at this time in getting out of the case?
At this time, we just want to be able to ensure that Mariah and Millie and Micah, all three have a place to live after Miss Hoffert's home. And that they're just on the right track and that we're able to support them with whatever they need.
And what about Mr. Rodriguez? He is still in a sober living facility?
Yes, he is in Houston. He actually completed an inpatient program back in March. He did complete that and we received the certificate, and then he went to that sober living home. He is about to be engaged in his BIP classes that we've requested of him. And he has not been able to drug test yet, but I will continue to work with him on that.
Why can't he drug test?
He was at work when I requested, and I just don't believe he ever went, so I'll request that he does it again.
Where's he working?
I know it's a fast food restaurant. I can't remember the exact name, but he is a manager there, so he's works a lot of hours.
Is it Popeyes?
Possibly. Yes, I believe so.
And so besides starting his BIP classes, what other services is he needing to do?
Just continue to randomly drug test for the department, and I will work on getting him an individual counselor.
Do you know how long he's supposed to be in the sober living facility?
I am not aware, but I believe he has up to a year, but I'm not exactly sure.
Are Mr. Rodriguez and Ms. Caldwell planning to be a couple when he's out of that sober living place?
Yes, I do believe that is their plan.
And so is that another reason that the department wants the motion to retain once more time, is to also work with him since they're going to be back together as a couple with their kids?
Yes.
Okay. So, and is there any Indian heritage in this family?
No.
Anything else that the court needs to be aware of regarding this family?
Not at this time. I'm really proud of how Millie's doing and Mariah and everything.
So you're asking the court to grant our motion to retain and maintain Millie's living situation with her mother, Miss Caldwell, but maintain the department as temporary managing conservator.
Yes.
And you believe this to be in the best interest of Millie?
Yes, I do.
I'll pass the witness.
Ms. Savage.
Once Miss Caldwell gets engaged with Miss Boone, is that going to be a virtual service that she can continue to engage in if she does move?
Yes, that is the plan.
Okay, perfect. And will that be the only other requirement other than drug testing that Miss Caldwell will need to continue to engage in?
Yes.
So at this point, the main obstacle to closing out the case is housing.
Yes.
Okay. Will you continue to work with Miss Caldwell to help find resources to locate housing for herself and her children?
Absolutely.
I'll pass the witness, Your Honor.
Mr. Brandon.
I don't have any questions, Judge.
Ms. Sims.
No questions, Your Honor.
Any other witnesses, Ms. Rep?
No, Your Honor.
Anybody else have a witness to call? All right,
No, Your Honor.
then. Thank you, Mr. Brandon. Ms. Sims, anything that you want to add?
I went out and visited at Miss Hofford's house with Millie on Tuesday, and as everybody can see, she is precious and smart, and everything is doing great. Mariah seemed very happy and healthy, and as you can see, the baby too. My only concern is the housing where they're at right now is kind of off the beaten path, and so they're very isolated and kind of supervised all the time. And so I think the motion to retain, I'm in favor of it because I would like to see Mariah off on her own with the kids in stable housing.
Okay. Thank you. Ms. Seawold, now you're good.
Okay, sorry. I visited Harper on April the 26th, and I agree it's a very isolated home, and my concern is also for her to have housing that's more reasonably located and on her own.
Okay. Well, it sounds like there's a plan in place to address that. So court's going to grant the department's motion to retain after hearing evidence and arguments of counsel. Court finds that extraordinary circumstances necessitate the child remaining in the temporary managed conservatorship of the department. Continuing the department as temporary managing conservator is in the best interest of the child. Court will retain the suit on the court's docket for a period not to exceed 180 days. And we're going to set some new dates here. New dismissal date is going to be November 30th, 2024. November 30th, 2024. Permanency hearing is going to be July 25th, 2024 at 1:30. July 25th, 2024 at 1:30. And the final trial is going to be September 26th, 2024 at 11:30. September 26th, 2024 at 11:30. For the purposes of the permanency hearing today, the court finds there's no Indian child heritage. The placement of Millie with Miss Caldwell in her home at this time is safe and appropriate, meeting her needs and in her best interest to continue. Court will make a finding that the parties are concerned about housing, and that is part of the extraordinary circumstances to continue to monitor what sort of housing we're going to get into, and also monitor Mr. Rodriguez's progress as he progresses through his steps. And while we're talking about that, I heard testimony that Mr. Rodriguez completed inpatient, and I want to give him a round of applause and tell him congratulations, because that's a huge step. And I'm also very proud of you, Ms. Caldwell, for managing everything that you're managing at this point in time. So good job, both of you. Continuing findings here, court will find that Millie is up to date on her checkups. She did not qualify for ECI services, and that both parents are in compliance with their family plans of service. And let's see. All that being said, just some legal jargon here that hopefully just stays legal jargon and doesn't affect our case anymore. We'll find that it's not safe to return a child to Mr. Rodriguez today. It is safe to keep the child with Ms. Caldwell, but that both parents still have some concerns to address before the court can make a finding that all the concerns have been addressed. And again, with the mother, that's just monitoring the living situation, and with father, it's getting him through the rest of his steps and finishing his program. Our next hearing, as I stated, will be July 25th, 2024 at 1:30. I want to admonish the parents that the state of Texas gives parents in CPS cases initially 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction and or termination. We've just extended the case, so you've got some more time. However, that time will end, and the dismissal date that I've stated is November 30th, 2024. So you have to continue doing everything that you're doing, continue to work hard. Remember that you're still in a CPS case. Reach out for help if you need it. Make sure you stay in touch with everybody, or your rights could still be subject to termination or restriction. Anything I failed to address?
Judge, I just have one question. July 25th at 1:30 is also Judge Mabry's Gillespie County docket. And so I didn't know if there was any conflict. I think I'm covering that docket as well. And so I didn't know if anybody else had conflicts with her on that day at 1:30.
I'll be on vacation. Can we move it a week early?
Well, I was gonna issue an order for you all to clone yourselves, and that would just solve all of our problems.
Can I get 2?
I need 3. Miss Greenlee, can we look at something else around that date or time to maybe avoid that conflict? I know we'll probably have to jump a month forward or a month backward because we only go to Gillespie once, usually a month.
Well, I mean, I can look at moving it a month back, but that may put us out. I mean,
well, our next permanency was going to be in July. We just did one, so we should be safe until August. So the permanency goal or permanency hearing will change August 22nd to 11:30.
and the trial, I'll have to take a look at the trial date because I have a date, our Gillespie date blocked off for the CPC conference. So I need to take a look at that.
Okay, then what we'll do, the permanency date, let's just hold off on what the trial date's going to be. And then when that order gets circulated, we'll make sure that we have a trial date in it. We're going to have to do a little moving around to do that. Okay. Well, then that'll be all. Thank you all for your time and your service. And if nothing further, all parties are excused.
I think so. Thank you.
Thank you, Judge.
Yes, Your Honor.
I've got a note that this one was going to probably take an hour. So I'll put you all in a breakout room and let you talk about whatever might be contentious still, and then we will go from there.
Yes, sir.
My client's trying to get in, Your Honor. They were given the wrong Zoom information, I guess, from what he said, but they're trying to get on.
All right. Okay. I think we've got everybody back from the breakout room. And it's my understanding from visiting with the attorneys for a moment that everybody agrees on a reset.
Yes, Your Honor.
Are you
Yes, Your
asking
Honor.
for 3262 mediation or just a reset?
No, we could mediate.
We could do that. I wouldn't oppose the pre-262 mediation, Judge.
Ms. Giannis?
That sounds like a good idea, Judge. I hadn't thought of that.
Me either.
Every once in a while, I'm good for something.
It's your day to day.
All right, then. Miss Greenlee, this is our initial setting on this adversary. And as long as all the parties agree to a pre-262 mediation and sign off on the order, we can go out as far as we'll all agree. Just have to get everybody's signature in writing.
The next occur day would be June 5th, and we could set it at 3:30.
Okay.
And so everybody would have to sign off on a pre-262 mediation and an extension of the emergency orders in their emergency jurisdiction.
Okay.
Could you give me that date one more time, Ms. Greenlee?
It's June 5th at 3:30.
Is that going to give you all enough time to mediate? Should.
I believe so. And if there's a problem, Your Honor, I'll get everybody back together if we have to maybe push it a little.
Okay, thank you, Ms. Dominguez. I mean, if you all think it's amenable to some sort of resolution, then I'm willing to give it more time if we need to. But I'm hoping you all can get it done within that time period. Just for giggles, Ms. Greenlee, what's the next date after that we have availability for the Kerr docket? It's not till 2 weeks after it, right?
Yeah, our next occur docket isn't until June 20. We have 2 dockets, the 5th and the 26th
Okay.
of
So
June.
the 5th
Those
it
are
is.
our only 2.
All right. I'll be at a conference the next week. That's why we don't have a docket. I'll be out 4 days that week. So, okay, then Miss Sutton and Mr. Gomez, I want to make sure you understand your attorneys will be in touch with you. I'm not even going to call this case today. I'm just going to reset it by agreement of the parties to June 5th, 2024 at 3:30 and order the parties to circulate a reset order that includes the pre-262 mediation and order the parties to sign the order based on their agreement that extends the court's temporary emergency jurisdiction and temporary orders out to June 5th, 2024 by agreement of the parties. That's the language in the code. Anything else that we need to take up today, Miss? Just a second. Would it be Miss Mitchell? Would it be you or Mr. Chavez? Mr. Chavez, is everything safe with placement?
Yes, sir.
Any concerns that we need to take up today regarding safety?
No, sir.
Okay, then that'll be the order of the court. Thank you all for your time and your service. And if nothing further, all parties are excused. Mr. Guel and Miss Casillas, sir, if you could please remove your hat, and then I'm going to ask you not to vape while we're in the courtroom, okay? Thank you.
Judge, I believe we have an agreement.
Just the hair follicle, Kathleen. I was trying to add that to the chat. Were y'all okay with that?
I didn't specifically ask him, but I'm sure it's something Judge will order.
I don't know why it wouldn't add.
All right. Got everybody back from the breakout room. All right, Mr. Dolezal, let's see. No. Why don't you just give us a call? I'll let you in. You can keep your video on and muted. It may let you do that. I don't know. There might be an echo. I can't read it. Call in. Oh, call in number. Could somebody text that to him? I don't have his, or put it in the chat.
I sent it to Lorraine. She just requested it from me, so I just did it just a couple minutes ago.
Okay. While we're getting that set up, I'm going to go ahead and call the case. And then by the time he calls in, we should be ready to go. Protective Services versus Pia Casillas and Jose Guel in the 198 Judicial District Court of Bandera County. So with that, while we're waiting for him to call in, can I please get announcements? And we will start with the attorneys for the parents and their clients. Go ahead, Ms. Savage.
Kathleen Savage for the respondent father, Jose Guel. We're ready, Your Honor.
Quincy Brannon, attorney for the respondent mother, Ms. Casillas. We're present and ready, Judge.
All right, Mr. Guel and Miss Fuller. Mr. Guel and Ms. Casillas, would you please unmute and both announce your names? Look for the microphone. There you go. You got it.
I'm Jose Guel, the father.
Pia Casillas, the mother.
Okay.
Deborah Fuller, attorney and guardian ad litem for the child. Your Honor, ready?
Amber Matthews, CPI investigator.
Jennifer Simmons, family-based caseworker.
And for the record, we have Mr. Dolezal, who's here for the department and should be calling in when he gets that information. I'll go ahead and swear the witnesses. Okay, if I get the parents and anyone else who's not an attorney or will be testifying, I'm going to go ahead and mute the parents again, just to cut down on background noise. And when I ask you some questions, I'll ask you to unmute again, please. Okay, since I know Mr. Dolezal can hear us, I'm going to go ahead and have Ms. Savage or Ms. Fuller, whichever one of you wants to do it, or Mr. Brennan, I don't know, to state the agreement on the record, please. I'll just let you all pick who's best to do that.
Your Honor, the parents are in agreement to work the PAT program, or they're in agreement to the TFF case, to work the PAT program, to complete no SAR evaluation, have random drug screenings, and counseling. And then there was not a discussion for a hair drug test to get a baseline, but that is a request of Ms. Fuller. I don't necessarily think there's oppositions. It was just something we weren't able to ask our clients before we got out of the breakout room.
Okay. Ms. Fuller, that's your understanding of the agreement?
Yes, Your Honor.
Mr. Brennan?
Yes, Your Honor.
Okay. Mr. Dolezal, I know you heard that by a shake or nod of your head. Can you affirm whether that's the department's agreement? All right, let the record reflect that Mr. Dolezal has nodded in the affirmative. Ms. Matthews, do you think that this agreement is in the best interest of the children?
Yes.
And do you think that abuse or neglect has occurred, or there's a possibility of abuse or neglect occurring in the future, and that these services narrowly tailored are necessary to protect the children?
Yes.
And do you believe that all reasonable efforts have been made to avoid removing the children or having these services, and that these services, if ordered, will be appropriate and necessary?
Yes.
Okay. I'm going to ask you, Mr. Well and Ms. Casillas, to unmute again, please. All right, I'm going to ask you both the same questions at the same time. You can both just answer together. Did you both have the opportunity to discuss this agreement with your attorneys?
Yes.
Yes.
Do you both understand what's expected of you in this agreement?
Yes.
Sir.
Were you forced in any way to agree to these services?
No.
No.
Were you given any inducements or made any promises to get you to agree to these services?
No.
Is this your voluntary agreement?
Yes, sir.
Are you asking the court to approve this agreement today?
Yes, sir.
Yes.
All right. Okay, now I've got, well, that's not Mr. Dozel, but that's Ms. Ortiz. Okay. Did you get that call-in number, Mr. Dozel? Okay. All right, while he's coming in, I'm going to just make sure you both understand that this TFF case, this is under the Texas Families First Act. This is the most or the least invasive way for you to work services with the department and belong, okay? These services are being offered to you. You'll receive referrals and you'll follow up with those. You'll make your own appointments and do all those things. You can get assistance when needed, but it is incumbent upon you to make sure that you set these things up. And if you work these services, which are paid for by the state, then we won't need to go to the next level. And when I say work services, I mean engage in those services, learn something and apply it so that you can demonstrate that the services have helped to address the concerns that brought us here. If you don't do that, then it's possible that the department can decide to take things to another more invasive level. Okay. All right, Mr. Dozel, I'm going to remove you on your video, and that way you'll just be here by phone. Can you hear me okay?
Yes, I can. Thank you.
Okay.
I apologize for this. Thought IT had this fixed, but
that's no problem. Again, I think you have a setting on your unit that your computer, your laptop, whatever it is, that it's a microphone setting that probably needs to be unmuted or turned up because the sensitivity is too low or it's muted and it's not picking you up.
Yeah.
There's no input.
Well,
okay. So Mr. Dozel, the attorneys have all agreed, and I know you've heard that the parents are in agreement. Is there anything that you wanted to add on behalf of the department / belong?
no, but you might check with Jennifer Simmons, Your Honor.
Okay.
I didn't have a chance to talk to her beforehand. I did talk to Amber, but not Jennifer.
Okay. Ms. Matthews has agreed and testified that it's in the best interest. Ms. Simmons, did you have anything to add?
In terms of the services for the parents?
The agreement.
Yes. I'm in agreement with it, but I do think that we should add for the child to get an ECI screening, and we wanted to talk to the parents some more about doing individual counseling.
Okay. Let's just go ahead and take that up right now. Is there any objection to the child having an ECI evaluation?
No,
No,
Your
Your
Honor.
Honor.
No.
And they already
Okay.
agreed to counseling, Your Honor.
Yeah, I do have counseling as part of the agreement, Ms. Simmons.
Okay, sorry, I didn't catch that part.
That's okay. So I think that addresses both of your concerns. Was there anything else?
My concern is that we do a hair follicle to get a baseline on the parents just to see where they're at with the drug use.
Okay. Let's do something real quick. I'm going to, back into a breakout room. Let's discuss that real quick.
Okay.
For the attorneys, if you could please go back into breakout room 1.
And will that happen for me, Your Honor?
I'm putting you in there right now.
Okay, thank you.
5-3. The request was made by the ad litem for a baseline hair follicle test. There's been no objection. So I'm going to order that. What I was discussing with the attorneys was if there is, and Mr. Well and Ms. Casillas excuse me, I want you to understand this. They're going to do a baseline hair follicle test, which I'm going to require you to report by, I don't know, Miss Matthews, you think you can set it up to have them do it by 5 o'clock tomorrow?
Judge, I met with the family yesterday evening, and we had already set it up for 3 p.m. today at G&G and Curry.
Perfect. So just make sure that there's, Mr. Well, they'll probably have to take hair from your beard. Just make sure you don't shave it or cut it. Miss Casillas, don't cut your hair. Don't alter it anyway. Don't bleach it. I mean, that's 53 minutes from now, so I'm not sure how much could be done in that time, but just leave everything the way it is. Okay. I want you to understand that if you're positive for anything, it's not going to count against you and it's not going to change our agreement. Okay. So I don't want you to be nervous about it. It's just going to tell us where you are with any alleged use. So that'll be ordered as well. All right. Then the court will find that the Texas Family First services are necessary in this case, and that the parties have agreed for the parents to work the Texas Families First program, the Parents as Teachers program, to submit to an OSAR assessment, random drug screenings, and individual counseling. And the request, obviously, for the baseline hair follicle has been granted and is part of the order. And there's also an ECI evaluation ordered on the child. Court will find that abuse or neglect has occurred, or the possibility of abuse or neglect occurring in the future there is a possibility, and therefore these narrowly tailored services are necessary and in the best interest of the child to protect the children, and that reasonable efforts have been made in this case to avoid services in this case, but they are necessary. And again, they're in the best interest of the children. Our compliance date is July 12th, 2024 at 10:30. So we're going to come back for a compliance hearing on July 12th at 10:30. And at that hearing, Mr. Wall and Ms. Casillas, Ms. Matthews and or Ms. Simmons, they're going to show up and they're going to tell me what you've done. They're going to tell me if you've been cooperative. They're going to tell me what you've completed and how engaged you are. Okay. The more cooperative you are, the more you complete and the more engaged you are, meaning that you're taking something from it. We're not just checking boxes. The faster this case will go. Okay. That doesn't mean that we're going to rush through things. It just means that the longer it takes you, the longer we're all going to be involved in your life, and the longer you're going to have to come back and see me. Okay. Anything further from anyone else?
Can I add something, Your Honor?
Yes, ma'am.
I just want to say that they were very cooperative with me last night. They were both very loving with the baby. Their home was very clean, and I was very impressed at how they interacted with each other and with the child. And so I think that this is going to be a success story, really.
Good. I'm glad to hear it. Sounds like we're getting started off on the right foot. So good for both of you. Okay. Well, if nothing further, I'll see you all back July 7th or July 12th, excuse me, at 10:30. And I appreciate y'all being able to come to an agreement, work this out. And I thank you all for your time and your service. And if nothing further, all parties are excused. And that concludes our docket for today. Have a good evening.